Hey everyone, and welcome to my video where I explain and demonstrate how to fill out OREC's Oklahoma Uniform Contract for Sale of Real Estate, Residential Sale. My name is Brad Anderson. I am the broker and owner of White Rock Realty. We operate in the states of Texas, Oklahoma, and New Mexico. And if you are not a White Rock Realty agent, maybe you should be. And if you are interested in learning more about us, you can go to this website and find out all about our coaching, training, and education opportunities and commission plan and all that. And if you want to get together over Zoom, there's a way to do that on that site. So that being said, this is part of a video series that I've done on the Oklahoma contracts. And I've put together this neat little cheat sheet where I list out what contracts you'll need for a listing transaction, a buyer transaction, and a lease. So if you want this, I am more than happy to share. Just reach out to me, either text me at this number or email me, and I will send that out to you. All right. So without further ado, let's launch into the contract. Okay. So this is obviously from the perspective of buyer representation. And in transaction desk, which is where I am now, you would have created a transaction and applied all the various documents that you need, and also fill out your buyer's name, seller's name, email address, all that information so that it transfers over here nice and neat and makes your job a lot easier. So the very first item in the contract process is our OREC acknowledgement of and confirmation of disclosures. So it pretty much says that it is hereby confirmed that prior to entering into the contract, the following items, where applicable, have been disclosed and or delivered. Buyer acknowledges and confirms that broker providing brokerage services to the buyer has described and disclosed their duties and responsibilities to the buyer prior to the buyer signing the contract. All right. That is the disclosure of brokerage responsibilities that we are instructed to provide any client. Outlines what their options are, describes what we're going to do for them, and so on. And then there's a box you can check if it's applicable for any in-house transactions where we represent both sides. And then it goes on to say, buyer acknowledges receipt of residential property condition disclosure or disclaimer form as applicable to residential property improved with not less than one nor more than two dwelling units pursuant to the property code. Okay, so the options are buyer has received property condition disclosure statement form, a buyer has received residential property condition disclaimer statement form, or the transaction might be exempt, right? Or disclosure not required under Residential Property Condition Disclosure Act. All right, so it is important that your buyer has received one of these items as mandated by any listing before you enter into this. All right, and then it allows for a space with regards to lead-based paint disclosure, and this would, of course, apply to any home that was built before 1978. If it was built in 1978 or more recent, you don't need this disclosure. All right, and then buyer acknowledges and confirms that they've received it, and these are my buyers in my example. And then the seller has to acknowledge and confirm that their broker providing services to them has described and disclosed their duties and responsibilities to the seller prior to the seller signing this contract. And then, like the spot above, it gives you an option if there are dual representation. All right, so the seller signs this, buyer signs this, and allows us to move on to the actual contract. So in my example, I'm going to assume that the home is taking out a conventional loan and they are part of an HOA. I review these documents in other videos, so I'm not going to do that here. Today is just for the uniform contract of sale. Okay, so party to the contract is going to be John Seller, Jane Seller, and then Troy Aikman and Mrs. Troy Aikman as the buyer. All right. It goes on to say, and as I've mentioned before, when OREC either bolds or underlines or both anything in the contract, it's important. So here it says all prior verbal or written negotiations, representations, and agreements are superseded by this contract and may only be modified or assigned by a further written agreement of buyer and seller. So whenever agents try and kind of step outside their lane, I always remind them that who is party to the contract? It's only the buyer and only the seller, not you as the agent. Okay. All right. So, property shall consist of the following described real estate located in, let's say it is Tulsa County, and the legal description is lot 45, block 21. This is the actual address. Okay, but this is important because let's say that the description or the listing included, I don't know, 7 acres of land, but it was broken out between one plot and another plot, but it had the same address. Well, you're going to have to break that out into the legal description, or else it's not enforceable. Okay. Together with all fixtures and improvements and all appurtenances subject to existing zoning ordinances, plat or deed restrictions, utility easements serving the property, including all mineral rights owned by the seller, which may be subject to lease unless expressly reserved by the seller in the contract, and excluding mineral rights previously reserved or conveyed of record, collectively referred to as the property. All right, so it's assumed that any mineral rights owned by the seller are conveyed unless they've leased them out, and they don't own them anymore. All right, so then it goes on to say paragraph 2, purchase price, earnest money and source of funds. This is a cash transaction. Okay, it defaults to the assumption that it is a cash transaction unless a financing supplement is attached. All right, and oh, by the way, we've noted that it is. All right, and the purchase price, let's just say it's $400,000, payable to buyer as follows. Within 3 days of the contract being fully executed by the parties, buyer or buyer's broker, if applicable, must deliver some earnest money. So let's just say it's $4,000. Okay, typical 1%, right? Earnest money 2. And let's just say it's Chicago title. And that's okay. All right. So we want to make it clear as to who deliver, or who it's being delivered to. Now, it gives you 3 days. All right. And that's calendar days. That's important. It's not business days, it's calendar days. All right. The holder of the trust account in which it will be deposited as partial payment of the purchase price and or closing costs. Buyer shall pay the balance. Okay. So these are business days. And it says, buyer shall pay the balance of the purchase price and buyer's closing cost at closing. If buyer fails to deliver the earnest money within the time required, seller may terminate the contract or exercise seller's remedies under paragraph 16 or both by providing written notice to buyer or buyer's broker before buyer delivers the earnest money. If the last day to deliver the earnest money falls on Saturday, Sunday, or a legal holiday, the time to deliver the earnest money is extended until the next day that is not Saturday, Sunday, or a legal holiday. So the best example is Labor Day and Memorial Day, because those are both Monday holidays. So if you execute a contract on Friday, well, Friday doesn't count as the first day. All right, that's important to note. Saturday is the first day. So if this contract says you have 3 days to deliver the earnest money to the title company, well, you got Saturday, Sunday, Monday. The last day is a holiday. Well, it's actually due on Tuesday. Okay, so the biggest thing to take away here is that it is not business days, it is calendar days. Closing, funding, and possession. The closing process includes execution of documents, delivery of deed, and receipt of funds by seller and shall be completed on or before, and you can put, so this is the closing date. Okay, so let's just say it is February 1st, 2025. Okay, here's a calendar in case let's just see if February 1st is even a weekday. It is not. So let's move that to the 7th. Okay. Or such later date as may be necessary in the title evidence paragraph of the contract. So there are other things within this process that may delay closing, but this is the date unless otherwise changed. Now, let me just tell you, the closing date is sacred. It is not a suggestion. If this date isn't met, and this is why I just feel so sorry for buyers sometimes, because this entire process relies on other people having to do their job correctly and efficiently. Title companies, lenders, inspectors, repair people, and they're at the mercy of that. And so if the lender can't get the documents together in time, or if the title company is dragging their feet, that closing date cannot be delayed, or else the buyer is going to be in breach for performance. Okay, so it then goes on to say possession shall be transferred upon conclusion of closing process unless otherwise provided below. So what might that be? Well, maybe the seller needs 3 days to stay in the home to organize their move, and the buyer has agreed to that. Well, you might put in here, buyer allows seller 3 calendar days from closing to remain in the home. Okay, it could be something like that. I'm just giving you an example of, something that you might put in there. All right. In addition to costs and expenses otherwise required to be paid in accordance with the terms of the contract, buyer shall pay buyer's closing fee, buyer's recording fees, and all other expenses required from buyer. This includes the buyer's agent's commission, unless it's entered into in a within the contract. All right. Seller shall pay documentary stamps required, seller's closing fee, seller's recording fee, if any, and all other expenses required from the seller. Again, including the seller's agent's commission. Funds required from buyer and seller at closing shall be paid by cash, cashier's check, wire transfer, or as determined by the provider of settlement services. So this reminds me of another point. When we talked about earnest money delivery, yes, that could mean a physical delivery of a check to the title company, but you only have 3 days to do it. A lot of title companies allow you to wire the funds or get them to them somehow electronically. This is the buyer's best course of action. Lots of times buyers are traveling, they're not in town, or they're just too busy, especially if you execute on a Friday. They only have Saturday, Sunday, Monday. And oh, by the way, the title company's not even open Saturday, Sunday. All right. So it becomes pretty difficult sometimes to get that over. Okay. And then it goes on to describe what stays with property. So accessories, equipment, and systems, the following items, if existing on the property, unless otherwise excluded in writing, shall remain with the property at no additional cost to the buyer. All right. And here they all are. And this list, I'm sure, has grown from the first time this contract was done, but lots of things spelled out. All right. So additional inclusions. The following items shall also remain with the property at no additional cost to the buyer. So let's say that the buyer has seen the home and they've noticed that there is a really nice washer dryer in the laundry room that they want. All right. Well, although that wasn't specified in the listing, it's here that the buyer can request it. Okay. Be as specific as possible. All right. So maybe that's what it is. All right. So similarly, as it's set up here, hey, these are included unless it says they're not. So let's just use as an example a common one, which is, see where it says here, lighting and light fixtures? Let's just say that the seller says, yeah, I know it says that, but listen, I have this light fixture hanging from ceiling in front entry foyer. All right. And maybe that was listed in the listing or through conversation between the buyer agent and seller agent that was expressed. All right. So that way the buyer knows, hey, they're taking that with them. Now, mind you, if the seller does that, they're not supposed to leave a vacancy in that light fixture. They have to replace it with something. All right. So just FYI. So paragraph 5 is an important one. Time period specified in the contract. So anything that is time bound is going to be keyed off of this date. Time periods for investigations, inspections, and reviews and financing supplement shall commence on. And you're going to put in a date here known as the time reference date, regardless of the date the contract is actually signed by the buyer seller. The day after the time reference date shall be counted as day 1. If left blank, the time reference date shall be the third day after the last date the signatures of the parties. Now, I don't recommend anything be left blank in these contracts, so this is important. So how do you figure out what this date is? Well, I would leave some time to account for going back and forth in negotiations before the contract is executed. So let's say that you submit this offer on January 15th. Well, there's going to be a couple of days that go back and forth, and it's going to be executed on a certain date. And you think that that date is going to be, I don't know, January 19th. Well, I might put the executed date here, the time reference date as January 20th. Okay. So January 20th is the time reference date. The 21st is day one. All right. And this will be important as we go through the contract. All right. But you don't want to make it the executed date because, or the date that you're submitting the offer, because you're going to cheat your client out of a couple of days. All right. Residential property condition disclosure. This just says that aside from the seller's disclosure or the disclosure statement or disclaimer, I don't know anything above and beyond that. Okay. Investigations, inspections, and reviews. All right. So this is the time that the buyer has to go in and do their due diligence, have an inspection done, and negotiate repairs to the TRR form. So buyer shall have X amount of days after the time reference date to complete any investigations, inspections, and reviews. So it says the default is 10 days. So that's pretty generous. So I would probably put in more like 7. That will give you time to get an inspector in there, see what's what, give you time to do repair, negotiate repairs and so on. Once you get past 7 days, your offer becomes that much weaker. All right. So just be mindful. Each transaction is going to be different, but best practice, probably around 7 days. And it says seller shall have water, gas, and electricity turned on and serving the property for buyer's inspections and through the date of possession or closing. So this is important because I've seen this happen. Seller puts their home on the market and then moves out, and they think it's okay to turn the utilities off, or they think it's okay to turn the utilities off when they get a contract. They figure, hey, this is going to go through. Why do I need to keep the utilities on? Well, in the listing agreement in the state of Oklahoma, it actually says, Mr. and Mrs. Seller, the utilities need to stay on. But it's also in the contract just as a reinforcement. Okay, because the inspector can't inspect a home properly without the utilities on. If required by ordinance, seller or seller's broker shall deliver to the buyer in care of the buyer's broker within 5 days after the time reference date any written notices affecting the property. Okay, this would be primarily the inspection report. 7B, buyer, together with persons deemed qualified by buyer at the buyer's expense, shall have the right to enter upon the property to conduct any and all investigations, inspections, and reviews. So this is not necessarily just an inspector. If the property has a pool, it could be someone that specializes in pools. It could be a septic system person. It could be a roofer. Anybody that has expertise in rendering an opinion about the property. All right. And these are the examples of who might go in there. And you can certainly put other in here too. I always put structural engineer, but number 8 kind of covers that. Structural inspection, which means, hey, is there any foundation issues? Well, sometimes, an inspector doesn't really go into detail about structural issues. If you think there's an issue with the foundation, you need to get a structural engineer out there. And then the other important paragraph is paragraph C, TRRs, treatments, repairs, and replacements. So this is, I sent an inspector in and I want to ask for repairs. C1 speaks to wood destroying insects. So this could be carpenter ants, could be termites, whatever. All right. Treatment and repair cost in relation to termites and other wood destroying insects shall be limited to the residential structure, garage, and other structures as designated in paragraph 13 of the contract and as provided in subparagraph C2B below. And then it goes on to say, things that are wrong. So paragraph 2, buyer or buyer's broker within 24 hours after the expiration of the time period referenced in paragraph 7A of the contract. That's here. So within 24 hours after that expires, if you want my opinion, you don't want to wait. You don't want to wait. You want to respect the seller. And if you've done the inspection on day one and you get it back on day one, you need to really decide, you, the buyer, what repairs and treatments or replacements you want done so you don't tie up the seller. But the contract gives you 24 hours within the expiration of that. Okay. Seller shall deliver to the seller. I'm sorry. Buyer shall deliver to the seller in care of the seller's broker, if applicable, a copy of all written reports obtained by the buyer, if any, pertaining to the property, and buyer shall select one of the following. So you got 24 hours after the expiration of that, in my example, 7-day period, to deliver any written report that you got on that property. So typically it's just going to be the inspection report, but it might be something from a structural engineer or a pool inspector, whatever. All right. So it says, here are your options, Mr. and Mrs. Buyer. If in the sole opinion of the buyer, results of the investigations, inspections, or reviews are unsatisfactory, the buyer can just cancel the contract, all right, without really giving the seller any chance to fix it. And believe me, it happens. Buyer goes in and looks at the property and thinks everything is great until he gets an inspection done and finds out the HVAC is broken and it's 20 years old. The hot water heater is leaking. It's 20 years old. There's all sorts of wood rot and things that, just overwhelms the buyer. And they say, I'm out. I'm out. Okay. You have to do that within that period. Okay. Or buyer, upon completion of all investigations, repairs, and reviews, waives the buyer's right to cancel, as provided in 7C2A above, by delivering to seller, in care of seller's broker, if applicable, a written list of notice of treatments, repairs, and replacements. This is what you want done. Of those items to be treated, repaired, or replaced, including repairs caused by termites and other wood-destroying insects that are not in normal working order, defined as the system or component functions without defect for the property, purpose, and manner for which it was installed. Defect means a condition, malfunction, or problem which is not decorative, that will have a materially adverse effect on the value of a system or component. So this is what you want done. And then it goes on to say, okay, well, if you've done this, well, then the buyer and seller shall have X amount of days, and it's 7 if you leave it blank, after the buyer or buyer's broker, if applicable, delivers that TRR form to negotiate what you want done. Okay, so I would say 3 is good. I know it says 7 is the default, but man, that's generous. You want to get out, you want to get on with this process. Okay. If a written agreement is reached, seller shall complete all agreed treatments, repairs, or replacements prior to closing at seller's expense, unless you work something else out in writing. Now, there is a TRR form, which I review in another video, but that is the written agreement that y'all are going to come to. All right. If a written agreement is not reached within the time specified in this provision, seller and buyer authorize the holder of the earnest money without any further written consent or authorization from either party to release the earnest money back to the buyer, and the contract terminates. Okay, buyer At buyer's sole option may deliver notice to seller or seller's broker no later than the time specific in this provision. The buyer accepts the property in its present condition and will proceed to closing, and all other provisions in the contract will remain in full force and effect. So even though y'all haven't come to an agreement, the buyer can still move on with the contract. So in my example, you have 3 days to negotiate in agreement to what's going to be done. And so let's say that the buyer says, look, the HVAC is broken. I want that serviced. I want the hot water heater replaced. And there is a broken doorknob in the entryway, to the door that enters the house. I want all that replaced. Well, let's say that the seller doesn't agree to any of that. The buyer can then cancel the contract, or they can say, you know what, I'm cool with all that. I'll just repair all that myself. All right, don't worry about it. And they can continue on with the contract. Or if you remember in the TRR form, the seller can agree to some of it, but not all of it. And if that's acceptable to the buyer, they can agree and they can move on. But something has to happen as a result of this negotiation. Okay, and it explicitly says what happens to the earnest money if both parties can't come to an agreement. Then in paragraph D, it speaks to expiration of buyer's right to cancel the contract. Failure of buyer to complete one of the following within the time periods in investigations, inspections, and review paragraph shall constitute acceptance of the property regardless of its condition. Those are perform any investigation, inspections, or reviews. So that to me would be the inspection, and or deliver a written list on a TRR form of items that you want treated, or cancel the contract, right? So believe me, time is of the essence here, guys. All of these time-bound things that you and your buyer have agreed to, they have got to be adhered to. So as a good buyer agent, what I would do is go into my calendar and mark what day all these expire. And a matter of fact, I do it one day earlier just to make sure that everyone is kept on track. Okay. And, once these days expire, it's really up to the lender and the title company to do their job, because at that point, you're just waiting. But getting back to the repairs and the TRR form, the seller is only bound to do these repairs and treatments by the closing date. All right. Now, yes, a buyer can do a walkthrough before they close on the property. And if things aren't done satisfactorily, well, there's some recourse there. But once these have been agreed upon, the seller has right up until the closing date to get them done. All right. So further explaining paragraph D, after expiration of the time periods in investigations, inspections, and reviews paragraph, buyer's inability to obtain a loan based on not being able to get insurance does not relieve the buyer from closing. That's an important one. So if the buyer can't get the loan, that's one thing. But if the buyer can get a loan, but they can't get insurance coverage, too bad. They have to close. All right. After expiration of time periods in investigations, inspections, and reviews paragraph, any square footage calculation of the dwelling, including but not limited to appraisal or survey, indicating more or less than quoted, does not relieve the buyer of the obligation to close on this transaction. So if the listing said the house was 2,100 square feet, it turned out to be 2,000 square feet, buyer still on the hook to close. Paragraph 7E, inspection of treatments, repairs, and replacements, and final walkthrough. Buyer or other person buyer deems qualified, so it doesn't have to be the buyer, may perform a reinspection of the property pertaining to all those things they asked for. Buyer may perform a final walkthrough inspection, which the seller actually may attend. Seller shall deliver property in the same condition as it was when the contract was signed. Okay, ordinary wear and tear excluded, subject to whatever repairs they made. And then lastly, all inspections and reinspections shall be paid by the buyer unless prohibited by a mortgage lender. So that might be an FHA or a VA loan. Okay. Risk of loss. Well, until transfer of title or transfer of possession, risk of loss to the property, ordinary wear and tear excluded, shall be upon the seller. All right, so what does that mean? If the closing date is February 1st and January 31st, a tornado comes through and wrecks the home, well, buyer hasn't taken possession yet. So that's on the seller to repair and replace and restore that home to its original condition as it was when the contract was signed. Okay, after the transfer of title or possession, risk of loss shall be on the buyer. Parties are advised to address insurance coverage regarding transfer of possession prior to closing. Acceptance of property. Buyer, upon accepting title or transfer of possession of the property, shall be deemed to have accepted the property in its then condition. Okay, so once closing happens, whatever condition it's in, the buyer accepts it. No warranties expressed or implied by the sellers, brokers, and or their associated licensees with reference to the condition of the property shall be deemed to survive the closing. Okay, so once it's closed, seller is absolved. Title evidence. Okay, and it clearly outlines what the seller pays for and what the buyer pays for. Seller's expense. Seller at seller's expense shall complete within 30 days prior to closing, agrees to make available to the buyer the following: either a complete and current surface rights only abstract of title certified by an Oklahoma licensed and bonded abstract company, or a copy of the seller's existing owner's title insurance policy issued by a title insurer licensed in the state of Oklahoma, together with a supplemental and current surface rights only abstract certified by an Oklahoma licensed and bonded abstract company. Okay, and a current uniform commercial code search certificate. Buyer's expense. Buyer at buyer's expense shall obtain either a commitment for an issuance of a title insurance policy based on an attorney's title opinion, which is rendered for the title insurance purposes for the owner or lender's title insurance policy, or an attorney's title opinion, which is not rendered for title insurance purposes. Then it goes on to talk about the survey. Seller agrees that buyer may have a licensed survey or enter upon the property to perform, check one of these: land or boundary survey, or a mortgage inspection report, or buyer elects not to receive any land or boundary report, survey, or mortgage inspection report unless required by title or law. The expense of the land or boundary report or survey shall be paid by. All right, so you check here, either buyer or seller. Okay. All right, I'm going to check this one and this one, just for purposes of an example. All right, so buyer gets a chance to examine all this. Buyer shall have 10 days after the receipt to examine the title evidence. So this is going to be their title commitment as given to them by the title company. If they don't like what they see, They have 10 days to object and give the seller enough time to remedy that, which he does not agree with. All right, so you got 10 days to examine the title evidence and deliver buyer's objections or requirements to the title to the seller or seller's broker if applicable. In the event the title evidence is not made available to the buyer within 10 days prior to the closing date, said closing date shall be extended to allow buyer 10 days from the receipt to examine the title evidence and to deliver buyer objections or requirements to title to seller or seller's broker if applicable. All right, so if they object to something, and if it's not 10 days, if it's 9 days before closing, they have 10 days from the receipt of that document to get it remedied. Buyer agrees to accept title subject to all these normal exclusions. The title company is not going to insure property against utility easements, any deed restrictions, any zoning regulation. These are things that the title company cannot control. So they are not going to cover that. So then it goes on to say, paragraph 10E, seller to correct issues with title, if applicable, and there might be a delay in closing. Upon receipt by seller or in care of seller's broker, if applicable, of any title requirements reflected in an attorney's title opinion or title insurance commitment based upon the standards of marketable title set out in the title examination standards of the Oklahoma Bar Association, the parties agree to the following. At seller's option and seller's expense, seller may cure title requirements identified by buyer and delay closing date for X amount of days, and it's 30 if it's left blank, beyond the closing date that was referenced in paragraph 3, or longer period as may be agreed upon in writing to allow a seller to cure buyer's title requirements. In the event the seller cures the buyer's objections prior to the delayed closing date, buyer and seller agree to close within 5 days of notice of those things being cured. In the event the title requirements are not cured within the time specified, the buyer may cancel the contract and seller and buyer authorize the holder of the earnest money to release it back to the buyer. Okay. Upon closing, an existing abstract of title owned by the seller shall become the property of the buyer. The most common things I've seen that go back to a seller to cure is, hey, survey revealed that your neighbor's fence is actually on this property that I want to go buy. You need to go fix that. Or a shed or some kind of encroachment. All right, and then paragraph 11 speaks to taxes, assessments, and prorations. Basically says that seller agrees to pay their portion, buyer agrees to pay their portion, and so on and so forth. Paragraph 12 speaks to a residential service agreement. What is that? That's a fancy name for a home warranty. All right, so you can check one of these. The property shall not be covered by a residential service agreement, or seller currently has a residential service agreement in effect on the property. Seller at seller's expense shall transfer that agreement with 1 year coverage to buyer at closing, or the property shall be covered by a residential service agreement selected by the buyer at an approximate cost of, let's say it's $600, and the seller agrees to pay half of that. Okay, and so this is just a home warranty that covers a buyer for a year. Additional provisions, I wouldn't put anything in here unless you're a lawyer, but that's where anything like that would go. And then it goes on to talk about if there's mediation involved, what happens there. choice of law and forum. This contract shall be governed by and construed in accordance with the laws of the state of Oklahoma without giving effect to any choice of law or conflict law rules or principles that would cause the application of the law of any jurisdiction other than the state of Oklahoma. So then it goes on to talk about breach and failure to close. Seller or buyer shall be in breach of this contract if either fails to comply with any material covenant, agreement, or obligation within the time limits required by the contract. Time is of the essence. All right. So if someone doesn't meet the due date, or one of the parties doesn't deliver something that they should have, that party is in breach. So that's why it's up to you, the agent, to keep everyone on track. So it goes on to talk about, well, what if it's breached by the seller? Well, if the buyer performs everything that they're supposed to do and the seller fails to convey the title or fails to perform any other obligation of the seller under the contract, then the buyer shall be entitled to terminate the contract upon delivery of written notice of termination to seller or seller's broker, if applicable, return the abstract to the seller and receive a refund of the earnest money, or pursue any other remedy available to them in the contract. Okay. So, if the buyer performs, but the seller can't convey the title because maybe it's hung up in probate or there's a cloud on title that prevents it from being conveyed, their seller's in breach, buyer gets a refund. Upon breach by the buyer, if at any time prior to closing the buyer's earnest money should fail for lack of delivery or lack of collection pursuant to paragraph 2, then the seller may, at seller's option, elect to do one of the following: terminate the contract upon delivery of written notice to the buyer, pursue any other remedy available at law or in equity, or enter into a written agreement between buyer and seller modifying the terms of paragraph 2. So just because the buyer breached doesn't mean that the seller wants to get out. They can, y'all can amend the contract to, cure whatever was breached. All right. If after the seller has performed seller's obligation under the contract and buyer fails to provide funding or fails to perform any other obligation of the buyer under the contract, then the seller may, at seller's option, cancel and terminate this contract and retain all sums paid by the buyer, but not to exceed 5% of the purchase price as liquidated damages, or pursue any other remedy available at law or in equity, including specific performance. So not just earnest money retention, but they can sue you. Okay. Paragraph 17, incurred expenses. Buyer and seller agree that any expenses incurred on their behalf shall be paid by the party incurring such expenses and shall not be paid from the earnest money. And then it goes on to say, well, what about the release of earnest money? Well, except where the release of earnest money is authorized by the parties under section 7C2BI and section 10E2, in the event a dispute arises prior to the release of earnest money held in escrow, the escrow holder shall retain said earnest money until one of the following occurs. So let me just stop. Unless it's explicitly described in anything above paragraph 17 as to how the earnest money gets dispersed if something happens, well, this is what happens. Right? Paragraph 7B. So unless it's not mutually dispersed otherwise, in other words, there's an argument, this is what happens. So a written release is executed by buyer and seller agreeing to its disbursement. Right? So if it's not recorded anywhere else prior to paragraph 17, but both parties agree to release each other and to disperse the earnest money accordingly to whatever the agreement was, that can be done in writing. Or agreement of disbursement is reached through mediation, or an interpleader or legal action is filed, at which time the earnest money shall be deposited with the court clerk, or the passage of 30 days from the date of final termination of the contract has occurred, and options 1, 2, or 3 above have not been exercised. Broker escrow holder, at broker's discretion, may disperse earnest money. Such disbursement may be made only after 15 days written notice to buyer and seller at their last known address stating the escrow holder's proposed disbursement. Now, I don't ever see that done because the title company does not want to be the judge and jury, but it's here. And then lastly, in the event the earnest money is held in escrow at a title company, the earnest money may only be released pursuant to paragraph 17B, 1, 2, or 3. Okay, so not 4. All right, delivery of acceptance of offer or counteroffer. The buyer and seller authorize their respective brokers, if applicable, to receive delivery of an accepted offer or counteroffer and any related addenda or documents. So this is just simply saying, I've hired a realtor to do all this stuff, and I authorize them to accept and deliver these documents. Paragraph 19, non-foreign seller. So according to the FERPTA Act, which is a federal act, seller represents that at the time of acceptance of this contract and the time of closing, seller is not a foreign person. So as deemed by the Real Estate Property Act. All right. So that should have been disclosed well before this contract was executed. But if an owner of property, because you don't have to be a legal citizen here to buy property in the US. So if that's the case and the seller is selling this to somebody and they're not a legal resident, then the IRS takes issue with that because they're going to get a profit from this home, theoretically, and they need to pay taxes on that. And so everyone needs to be aware of whether or not this person is or is not a foreign seller. All right, the title company will guide you as to what happens if they are. Okay, buyer affidavit compliance. Buyer represents that at the time of submission of this purchase offer and at the time of closing, buyer is either a U.S. citizen, Native American, or non-citizen alien who is or shall become a bona fide resident of the state of Oklahoma, or a business entity or trust in compliance with 60 OS 121-122. Buyer further represents that buyer is eligible to execute the required affidavit of land or mineral ownership provided by the Attorney General of the state of Oklahoma as required by 60 OS 121. And then paragraph 21, termination of this offer. The above offer shall automatically terminate on, and you can put, whatever date you want at 5 p.m., just an example. All right. And then there's a spot for offer is rejected and seller is not making a counteroffer. All right. So that's to be filled in by the seller if applicable. All right. And then this is where you execute the date. So paragraph 22, execution by parties. So, you're going to send this to your buyer first. They're going to, put a date in here, and then it's going to go to the seller. And it may be a day before the seller signs it. All right. So that's why the time reference date is so critical. Okay, because maybe you find out in your course of conversations, because remember, you're the buyer's agent, that the seller doesn't even live here anymore. and they live in Washington State and they're 2 hours behind us. Well, they're not going to get to this within a day, right? So the date here and date here may be different. So that's why the time reference date is so important. All right. So then you're going to fill all this out completely. Don't leave any of this blank. All this is in the listing. So there's no excuse not to fill it out. Please, please, please fill this out. All right. And then you're going to send it to your buyer for initials and signature through transaction desk, AuthentiSign. And then once that comes back, you're going to send all of this out with your buyer's lender's pre-qualification letter and wait for a reply from the seller or seller's agent. Okay? All right. That was it on how you fill out the Oklahoma Uniform Contract of Sale of Real Estate for a residential sale. As always, if you have any questions, please reach out, and I hope you found this video helpful.